Hi, I'm Greg Dell with Dell Disability Lawyers, here with attorney Cesar Gavidia. And Cesar, we're going to talk about one of the most important issues in any disability claim. And really that has to do with how you present your medical condition to the disability insurance company. And the reason it's so important is because when you read any definition of disability, it always starts with due to disability, you're either unable to perform the duties of your occupation or any occupation. But it starts with due to disability. So the first thing you got to get through is what is the medical condition? And one of the things that we understand extremely well and that people watching these videos and handling any disability claim have to understand is that diagnosis doesn't equal disability. Now, we hate to hear that from the insurance companies, but it is a true statement. Just because you're diagnosed with a medical condition doesn't mean that all of a sudden you have all of these medical restrictions and you can't do anything, or you can't work in a job, or you can't function or do anything anymore. So because of that, a lot of people just think if the doctor says, I have a herniated disc in my back, I have a torn labrum in my shoulder, I have a bad knee, I have a cancer diagnosis, that means I can't work. That in itself is not going to be enough for the disability insurance company. And that's extremely important for people to understand, because that's probably the number one reason why these claims get denied, is that there's not enough medical support. So what we've done a lot of is we've put together a lot of these videos where we have specific discussions about each and every medical condition and how the disability insurance companies look at each of these medical conditions. But what I'd like you to talk about is that why is it so important to, as a disability lawyer, to truly understand and have experience in working with people that have had these specific medical conditions, and how that relates to you helping to get these people approved?
Right. Well, look, it all starts with that foundation. Your medical support, your medical records, basically the documentation, the proof that you have this sickness, this injury that is your disability and is preventing you from performing the occupational duties, the duties of your occupation, or in some cases being able to function and work in any significant capacity at all, in any job, in any occupation. So you made the point that diagnosis does not equal disability. So you're diagnosed with a sickness, or you're diagnosed with an injury, and in some cases you mentioned herniated discs. Where does that fall in the category of sickness or an injury? And people are kind of confused by that. Well, I'm not thinking it's a herniated disc, it's not cancer. Does that mean it's not a sickness? It's not an injury because it's arthritic, it's progressed and developed over time. Is it not an injury? And it falls in this kind of category of being a sickness or a disease or a condition or this process that's going on in your body. And just simply for the fact that that's happening, it doesn't mean necessarily that you're not able to work. What kind of makes it rise to that level of causing of that causal nexus of being, making some sort of connection or some sort of link to where you're not able to function at work or create a limitation for you, and physical limitation for you in some way, is the symptomology, right? Is the severity of those symptoms. And just because you may be experiencing some severe symptoms, or you're highly symptomatic, or it's causing, a lot of pain or different sensory problems like paresthesia or something like that, where you're feeling things in your extremities and your limbs, because that's happening, again, the fact of that alone is not going to cause the insurance company to say, well, we think you're disabled now, and we're going to accept your claim and pay your benefits. Because if the records do not basically establish or show that these symptoms are intense enough, frequent enough to cause some level of limitation for you, where you couldn't perform your occupational duties or the duties of any occupation, then they're going to deny the claim. So you have to have a real firm understanding of, the client is having these symptoms, is having this, caused by perhaps this disease or this injury. Now, we need to know, you have to have that experience and knowledge and expertise to understand how that has to be documented within that client's medical records and their medical charts in order for the insurance company to likely accept the claim and pay it.
So I want to comment on that because I know when potential clients call me and I'm talking to them and I say, so tell me what's going on. What is the medical condition that's disabling you? And they'll go ahead and tell me, what it is. And then I'll say to them, well, what doctors have you seen? And sometimes they'll say, I've seen one, or I've seen two, or I've seen three or four. And right away I'm asking those questions because the way that we're trained, the way we look at it is, I'm asking in the manner as to how the disability claims consultant who gets this claim or the claims examiner at the insurance company is going to review the claim. And what kind of evidence is going to be available from the claimant to give to the insurance company, because the insurance company people are trained in one way to basically just gather all the information and then they give it to their in-house nurse or doctor. And their in-house nurse or doctor is going to look at it in a manner not to say what information is here to approve the claim. They're going to look at it to say what information is weak here, what information is not here so that I can deny the claim. These insurance companies, in my opinion, aren't necessarily looking to do the right thing to approve the claim. They're in business to have their premium collections exceed what they pay out. And unfortunately, many of the disability companies, when they get these claims to review, are looking for reasons to deny the claim. So, what do we do as lawyers, and why is it so important to have this medical knowledge? Is we have to understand, and the claimants have to understand, that doctors are not documenting the medical records for the insurance company. And you went through that and just said how important it is that everything has to be in your medical records. But you know that doctors treat the patient, and they're putting notes in there to remind themselves as to what's going on for a diagnosis, and what do they need to, what's the course of treatment going to be, and what's the reminder for the next visit to see what the progression is. Not, let me put in every single thing in here because the insurance company is going to look at it, and if I don't put it in, they're going to pick it apart. Yep. But unfortunately, that's how disability insurance companies get away with denying a lot of these claims, because if you don't have someone, or you don't have a doctor, which is rare, who has absolutely phenomenal record taking, which doctors just don't do that. They don't have the time. The insurance companies have beaten up the doctors so much and what they're getting paid, and they don't have the time to document it appropriately.
And look, and now when you're going to these, you may go to these larger healthcare institutions where they're doing, the record keeping through like a MyChart or something.
Well, it's all electronic requirements now. So
right.
Almost everybody's doing that.
And you're just basically finding the bare bones in those summaries and in those notes of what the patient is diagnosed with, what they were prescribed. They're not really going into detail about the level of pain that they're having or what kind of limitations they're having. Sometimes the patient's not even properly expressing that to their doctor, and they have no idea that this is happening. So I think it's really important for whether it's and I would recommend it from the client themselves, is really you have to go through your own medical records and be objective about what you're seeing there. Does the picture that's being painted there appear like a disabled person? Does it appear like somebody who's not able to function in their job? Because if the answer is no, then you know where the problem is and how you need to address it.
That is one thing, but I don't think a lot of claimants, if they review the records on their own, do they know? Because the other thing is, take any medical condition, Cesar, and I mentioned herniated disc before, or a back condition. You know every single piece of objective evidence versus subjective, and objective means physical, MRIs, X-rays, EMG, any kind of tests that you take is usually an objective finding where you can tangibly touch it. Versus subjective findings are the doctor stretches you and you say, yes, that hurts, or they do a range of motion and you bend forward and they say you're only at 50% as opposed to 100%. That's subjective because a human can stop themselves from going forward. But no matter what the medical condition is, when you have a trained lawyer who's now presenting not just the medical, but now from a medical legal perspective, you know what additional testing that even though your doctor didn't recommend it, that you say to your client, you need to go get this test. And in almost every condition, now listen, not every medical condition has objective testing, and not necessarily even if the results don't come back with a favorable finding or a finding that further supports it, it doesn't mean that you don't have that condition. For example, carpal tunnel syndrome, of the wrist. A lot of times people get an EMG for that, even though they're having tremendous wrist pain. A doctor says your diagnosis is carpal tunnel, and people can't write or type or do any of those things, right? Well, they go for an EMG test. Well, the EMG test comes back with no findings. That doesn't mean you don't have carpal tunnel, but it's still important to go out and try to get that test, even if your doctor didn't give it. Now, we know, because we've litigated that and represented so many people with carpal tunnel, that every respectable orthopedic or board-certified hand surgeon is going to say that more than half of the EMG testings that I request for people with carpal tunnel, they're not going to necessarily have a positive finding.
Right.
So it doesn't mean that you're not disabled by that. But the insurance company, even if you don't even go for the test, you haven't set yourself up to even address that. If you get the objective testing, the EMG of that, then you can say insurance company, look, I have it, it's further evidence. If you don't, then as a disability attorney, you got to go back to the doctor and say, can you explain, cut off the issues as to why it wasn't a positive finding, but yet the claimant's complaints are still reasonable, therefore cutting off any insurance company doctor's argument that not having a positive, if you don't have a positive EMG finding for carpal tunnel, then there's no way you're disabled.
Right.
So that's just one example of the hundreds of different disabling conditions as to how, as a disability attorney, you know ahead of time in your mind what evidence is the disability insurance company looking for. What are they going to say is missing? What do I have to guide my client to have their doctor physically write into the medical record so that they can't say, you didn't say this, you didn't say that. And it's continuous. It's not just a one-time deal to help get you approved or a one-time deal to win the appeal. It's something that has to go on every single time that the claimant goes to the doctor. And that's why we always, educate our clients who we're representing. Clients have us manage their claims even when they get approved so that this keeps going, because doctors, they just don't want to be bothered with this. And it's a difficult cycle. So, highly recommend that people check out our videos that just by searching our website that are related to a specific disabling condition. We also have, as you know, Cesar on the website where we have questions that are related to the specific medical condition. We have a whole filter in the search page of our website where you can click on your medical condition and see all kinds of cases that we've resolved specific to that medical condition. It will blow your mind how much information there is with regard to your medical condition and how each and every disability insurance company looks at that and evaluates that. And the reason that's so important, Cesar, for claimants or people who aren't even our clients is it can help them. It will help them to stay on claim. It will help them to get approved. It will help them learn how to speak to their doctors so that they can avoid a disability denial and keep them approved for as long as possible. So if you have a long-term disability insurance claim, please reach out to Cesar, myself, any of our disability attorneys. We're available to help you no matter where you live in the country. We always provide you a free initial consultation. We'd love for you to subscribe to our YouTube channel so you can continue to get the benefit of these videos that we do all the time. And we look forward to speaking with you should you need us in the future.